Let us look at an interesting case from the Court of Justice of the EU in December 2022 on legal privilege and human rights aspects of it. What you see here is a building in Luxembourg called Villa Vauban, which is actually one of the first houses of the CJEU. Today it's a museum, but this is where the CJEU was hosted, I believe, in the late 40s, early 50s. So here is the judgment of the court. You can see a December 2022, and it involves the Flemish bar associations and the Belgian bar associations and the Flemish government. And it is the Grand Chamber of the Court of Justice, and they always say, if you want to know how important a case is for the EU, count the judges. It doesn't get much bigger than this. So let's see what was going on. But before we do, just a quick reminder on what mandatory disclosure rules are. During the OECD BEPS action plans, Action 12 involved taxpayers mandatory reporting any aggressive tax planning structures that they are involved in. And during that time, the idea was initially that intermediaries should report this, because intermediaries were the ones, primarily the big four firms, running around pushing tax structures to as many taxpayers as they could sell them to. And the idea was, if they report these things to the governments can act in time if they do not like the products being sold. Somehow in the process of all of this, it seems like taxpayers now end up with the brunt of the burden of compliance with mandatory disclosure rules. But that is not how it started. And during BEPS, they did discuss the attorney-client privilege. And what you see here is paragraph point 3, paragraph 70 of the Action 12. The existing legislation recognizes that legal professional privilege may act to prevent the promoter from providing the information that needs to be disclosed, right? In this circumstance, the obligation to disclose falls on the scheme user, so the taxpayer. Alternatively, the client has the option of waiving any right to legal privilege, and the obligation to disclose remains with the promoter. The legal professional asserting legal privilege must advise clients of the obligation to disclose, and must also advise the administration that the legal professional's obligation to disclose has not been complied with because of the assertion of legal professional privilege. And then the recommendation by Action 12 was, countries adopting mandatory disclosure rules will need to decide whether or not they introduce a dual reporting requirement. Where the primary reporting obligation falls on the promoter, it is recommended that the reporting obligation switches to the taxpayer where the promoter asserts legal professional privilege. So this is BEPS Action 12, and then the EU implemented BEPS Action 12 through a directive called DAC6, which amended the directive on exchange of information between member states. And you can see here, so we're talking about Directive 2018-822 of 25 May 2018, and it amends the Directive 2011-16, which is on mandatory automatic exchange of information in the field of taxation. And you can see that, in the considerations, the directive says it should not be ignored either that in certain cases, the reporting obligation would not be enforceable upon an intermediary due to legal professional privilege, or where there is no intermediary because, for instance, the taxpayer designs and implements a scheme in-house. In other words, you can't always rely on intermediaries, and therefore sometimes you need taxpayers. It would therefore be necessary to shift the reporting obligation to the taxpayer who benefits from the arrangement in such cases, right? And this was supposed to, as you can taste from the wording, be a relatively narrow amount of reporting to be done by taxpayers themselves. And then it ends with it has adopted this directive, and in Article 1 of the directive, or then Article 2, it says the following, the following article will be inserted in Directive 2011-16, Article 8AB, scope and conditions of mandatory automatic exchange of information on cross-border reportable arrangements. Each member state may take the necessary measures to give intermediaries the right to a waiver from filing information on the reportable cross-border arrangement where the reporting obligation would breach the legal professional privilege under the national law of that member state. And look at these words, under the national law of that member state. Remember that a Dutch attorney's legal privilege under Dutch law does not bind the Belgian government or the French government. The French government is not subject to Dutch law, and I doubt that a Dutch barrister has legal privilege protection in France because he is not a French barrister, or she, right? Just going further with the text, in such circumstances, each member state shall take the necessary measures to ensure measures to require intermediaries to notify without delay any other intermediary, or if there is no such intermediary, the relevant taxpayer of the reporting obligations under paragraph 6. So you see that the EU directive varies from Action 12. Action 12 said if the intermediary claims legal privilege, then the taxpayer must report. EU law says if the intermediary claims legal privilege, then the intermediary should tell the other intermediaries involved that they need to report, right? So the EU tries to keep the obligation for reporting with the intermediaries because they're the ones that are promoting and selling these structures. And then the EU says, however, if there are no other intermediaries, then the taxpayer itself should report. And if we then look at that, at the annex to DAC6, I mean, there were a number of hallmarks, and if your transaction crossed these hallmarks, then you had to report. Either the intermediaries had to report, and if no intermediary report, then the taxpayer should report. So it was a main benefit, and if one of the main benefits of a transaction was a saving of tax or tax advantage, then you had to report it. And then there were specific and generic hallmarks. A generic hallmark was, for instance, a confidentiality agreement by the intermediary. The intermediary receives a success fee, or an arrangement that has substantially standardized documentation, because again, the Big Four was selling these transactions, at least in the late 90s, by not the dozens, but by hundreds of transactions. And then you have specific hallmarks, such as acquiring loss-making companies to use the losses, converting income into capital, circular transactions, resulting in round tripping, so that you just end up with interest deductions, but nothing really changes. And then there were hallmarks with regard to cross-border transactions, beneficial ownership and exchange of information, and transfer pricing. So what happened here was that the French proceedings, the French Bar Association, I believe, asked whether they should be fulfilling the French law, which implements the directive requiring the reporting, and so there was a case before the Conseil d'État, and that court referred preliminary questions to the Court of Justice, and we take off from there. Paragraph 17 says that court, the Conseil d'État, decided to stay the proceeding and to refer the following questions to the Court of Justice for preliminary ruling. Does Article 1.2 of Directive 2018/822, what that we just looked at, infringe the right to a fair trial as guaranteed by Article 47 of the Charter, and this is the Charter on fundamental freedoms for the EU, and the right to respect private life as guaranteed by Article 7 of the Charter, in that the new Article 8AB5 provides that a member state is obliged to require intermediaries to notify any other intermediary or the relevant taxpayer of their reporting obligations, insofar as the effect of that obligation is to oblige a lawyer acting as an intermediary to share with another intermediary, not being his client, information which he obtains in the course of essential activities from his profession, even in the absence of pending legal proceedings, right? So there are a number of questions here. The first is, it's not the whole directive that's wrong, it's just the fact that I, as a lawyer of company X, must now tell other advisors, intermediaries, that I cannot report and they need to report. If they are there, if there are no other advisors, then I should tell the client, company X, that they should report, right? But is that request to tell the other advisors that they should report against legal privilege, because they may not know that I am advising the client as a lawyer, is the issue. And then the second question is, is that the case even if we're just doing aggressive tax planning and there's no legal proceedings pending yet? And the court reiterates this in point 18, As a preliminary point, it should be noted that although the question put refers to the obligation to notify laid down Article 8AB5, both with regard to intermediaries and in the absence of any intermediary, the taxpayer, it is apparent from the request that the referring court is in fact seeking to ascertain only the validity of that obligation insofar as the notification must be made by a lawyer acting as an intermediary to another intermediary who is not his or her client, right? So that's the only issue at stake here. Does mandatory disclosure rules with regard to this harm the legal privilege of lawyers and their clients? And if we look at the Charter of the Fundamental Rights, so this is what the court is referring to, right? We have two articles at play. The first one is freedoms, the respect for private life, private and family life. Everyone has the right to respect for his and or her private and family life, home and communications, and it's primarily communications. So you have right for respect for your private communications. In other words, can the directive ask the lawyer to tell other advisors who may not know that he is the lawyer about the fact that he is the lawyer, right? That's the first question. And the second one is with regard to Article 47, and this is right to a fair trial, the right to an effective remedy and to a fair trial. Everyone whose rights and freedoms guaranteed by the law of the Union are violated has the right to an effective remedy before a tribunal. So he must always be able to go to a court, right? Everyone is entitled to a fair and public hearing within reasonable time by an independent and impartial tribunal previously established by law, so you can't just do it on the spot. Everyone shall have the responsibility of being advised, defended, and represented, and you cannot know what your lawyer tells, what their lawyers tells them, right? Legal aid shall be made available to those who lack sufficient resources. So this is the EU Charter on Fundamental Rights.